Question 1. The evaluation methodology shows that a Florida-registered paralegal is assisting an attorney in a breach of contract civil litigation matter. The client has provided a substantial volume of documents related to the contract and alleged non-performance. The paralegal's initial tasks include reviewing these documents, identifying potential witnesses, and conducting preliminary factual interviews. Following this, the paralegal is responsible for drafting initial discovery requests, specifically interrogatories and requests for admission, to be served on the opposing party. Which of the following approaches best reflects the regulatory framework and ethical obligations for a Florida-registered paralegal in this pre-suit and early discovery phase? Option A. Conduct a thorough review and organization of all client-provided documents, identify key factual areas, and draft targeted interrogatories and requests for admission that seek specific admissions of fact and identification of relevant documents, ensuring all requests comply with Florida Rules of Civil Procedure 1, 340 and 1, 370. Option B. Immediately begin drafting a comprehensive complaint based on the client's initial narrative, without a detailed document review or witness interviews, and then serve a limited set of discovery requests focused only on confirming the client's allegations. Option C. Rely primarily on the client's summary of the documents and witness statements, and draft broad interrogatories seeking general information about the opposing party's business operations and extensive requests for admission covering all aspects of the contract. Option D. Delegate the document review and witness interview process to a junior administrative assistant and draft discovery requests based on a template used in a previous, unrelated case, without consulting the supervising attorney on the specifics of the current matter. The correct answer is A. Conduct a thorough review and organization of all client-provided documents, identify key factual areas, and draft targeted interrogatories and requests for admission that seek specific admissions of fact and identification of relevant documents, ensuring all requests comply with Florida Rules of Civil Procedure 1, 340 and 1, 370. Explanation. This scenario presents a professional challenge because a Florida-registered paralegal, FRP, must navigate the intricate rules of civil procedure and discovery while maintaining ethical obligations to their supervising attorney and the court. The FRP's role in fact-gathering and document review during the pre-suit investigation phase is critical for assessing the viability of a claim and preparing initial pleadings. Failure to adhere to Florida Rules of Civil Procedure regarding discovery, particularly the scope and limitations of interrogatories and requests for admission, can lead to sanctions, exclusion of evidence, or even dismissal of the case. The FRP must understand the boundaries of their authority and the importance of accurate and complete responses, always under the direct supervision of an attorney. The correct approach involves meticulously reviewing the client's provided documents, identifying potential witnesses, and conducting preliminary interviews to gather factual information relevant to the alleged breach of contract. This includes organizing documents chronologically and by category, and noting any discrepancies or missing information. Subsequently, the FRP would draft initial interrogatories and requests for admission, focusing on obtaining admissions of fact and identifying key documents from the opposing party, all while ensuring these discovery requests are narrowly tailored to the claims and defenses in the case and comply with Florida Rule of Civil Procedure 1, 340 and 1, 370. This methodical approach ensures that the pre-suit investigation is thorough and that discovery efforts are targeted and compliant with procedural rules, laying a strong foundation for the subsequent stages of litigation. An incorrect approach would be to rely solely on the client's initial narrative without independent fact-gathering or document review. This overlooks the FRP's duty to assist in developing a comprehensive understanding of the facts and could lead to incomplete or inaccurate pleadings. Another incorrect approach would be to serve overly broad or harassing discovery requests, such as interrogatories that seek irrelevant information or requests for admission that attempt to elicit legal conclusions rather than factual admissions. Such actions violate Florida Rule of Civil Procedure 1, 370a, which states that requests for admission are to be used to obtain admissions of fact or opinion of fact or application of law to fact, and can result in sanctions. Furthermore, failing to properly organize and analyze documents gathered during the pre-suit phase would hinder the attorney's ability to prepare effective pleadings and discovery, demonstrating a lack of diligence and potentially violating ethical duties of competence. The professional reasoning process for an FRP in this situation should begin with a clear understanding of the case's factual background, as presented by the client and supervising attorney. The FRP must then identify the specific legal claims or defenses involved and determine what factual information is necessary to support or refute them. This involves consulting the Florida Rules of Civil Procedure for guidance on pre-suit investigation, pleading requirements, and discovery procedures. The FRP should prioritize thoroughness and accuracy in fact gathering and document review, ensuring all information is organized and readily accessible. When drafting discovery, the FRP must focus on obtaining specific, relevant information that will advance the case, always staying within the bounds of procedural rules and ethical guidelines, and seeking attorney approval for all substantive filings and discovery requests. Question 2. Benchmark analysis indicates that a Florida-registered paralegal, FRP, is assisting a supervising attorney on a complex litigation matter. The client has requested specific information about the case strategy that the attorney has deemed confidential and has instructed the FRP not to disclose any details about the strategy to the client, even if directly asked. The FRP receives a direct inquiry from the client seeking clarification on the case strategy. What is the most appropriate course of action for the FRP? Option A. Directly explain the case strategy to the client, as the client has a right to understand their case. Option B. Advise the client that the attorney's instructions are unethical and that the FRP will be reporting the attorney to the Florida bar. Option C. Inform the client that the attorney has instructed them not to discuss case strategy and offer to relay specific, attorney-approved questions to the supervising attorney for a response. Option D. Contact the client directly and explain the case strategy, assuring them that it is in their best interest. The correct answer is C. Inform the client that the attorney has instructed them not to discuss case strategy and offer to relay specific, attorney-approved questions to the supervising attorney for a response. Explanation. This scenario is professionally challenging because it requires a Florida-registered paralegal, FRP, to navigate a situation where a supervising attorney's instructions potentially conflict with established ethical guidelines and procedural rules governing client communication and representation. The FRP must exercise independent professional judgment, recognizing that direct attorney supervision does not absolve them of their ethical obligations or the responsibility to ensure proper legal procedures are followed. The core challenge lies in balancing loyalty to the supervising attorney with the paramount duty to the client and the integrity of the legal process. The correct approach involves the FRP seeking clarification from the supervising attorney regarding the client's request and the attorney's instructions, while also proactively researching the relevant Florida rules of professional conduct and Florida rules of civil procedure. This demonstrates a commitment to ethical practice and adherence to procedural requirements. By initiating a dialogue with the attorney and grounding their concerns in specific rules, the FRP acts as a responsible member of the legal team, ensuring the client's interests are protected and that the attorney's directives are legally sound and ethically permissible. This approach aligns with the FRP's role as an extension of the attorney, but one that also possesses a degree of independent ethical responsibility. An incorrect approach would be to blindly follow the attorney's instructions without question, even if they appear to violate ethical or procedural rules. This failure to exercise independent judgment and to verify the legality and ethicality of the instructions could lead to a breach of client confidentiality, misrepresentation to the court, or other serious ethical violations, potentially jeopardizing the client's case and exposing the attorney and the FRP to disciplinary action. Another incorrect approach would be for the FRP to unilaterally decide to ignore the attorney's instructions and proceed with their own interpretation of what is best for the client or the case, without first attempting to communicate their concerns or seek clarification. This bypasses the attorney supervision requirement and could lead to procedural errors or missteps that harm the client's interests. The FRP's role is to assist the attorney, not to act independently in contravention of their directives, unless those directives are clearly unethical or illegal, and all attempts at clarification have failed. A further incorrect approach would be for the FRP to contact the client directly to discuss the attorney's instructions and their own ethical concerns without the attorney's explicit consent. This would violate client confidentiality and could undermine the attorney-client relationship, creating a conflict between the attorney and the client. The professional decision-making process for similar situations should involve a tiered approach. First, attempt to understand the attorney's instructions and the rationale behind them. Second, if there are ethical or procedural concerns, research the relevant rules and case law. Third, communicate these concerns clearly and respectfully to the supervising attorney, citing specific rules or procedures. Fourth, if the attorney insists on a course of action that the FRP believes is unethical or illegal, the FRP should consider escalating the issue within the firm or, in extreme circumstances, seeking guidance from the Florida bar. Question 3. The review process indicates that a Florida-based small business owner, MS Anya Sharma, engaged in a series of email exchanges with a supplier regarding the purchase of custom-designed widgets. In an email dated October 1st, MS Sharma wrote, "I am interested in purchasing 500 of your standard widgets at $10 each, delivered by November 15th. The supplier responded on October 3rd with an email stating, "You can supply 500 widgets at $10, 50 each with delivery by November 20th. Please confirm." MS Sharma replied on October 4th, "Agreed, I will take them." Subsequently, the supplier failed to deliver the widgets by November 20th, and MS Sharma seeks to understand her legal recourse. Based on Florida law and the Uniform Commercial Code, UC, Article 2, what is the most accurate assessment of the situation? Option A. A binding contract for the sale of goods was formed, and the supplier's failure to deliver constitutes a breach, entitling MS Sharma to remedies under the UCC. Option B. A binding contract was formed, but the supplier has a valid defense due to unforeseen logistical challenges that prevented timely delivery. Option C. MS Sharma's email on October 4th constituted a counteroffer, which the supplier never explicitly accepted, thus no contract exists. Option D. No binding contract was formed because MS Sharma's initial email was an invitation to negotiate, and the supplier's response introduced new terms, which were not definitively accepted. The correct answer is A. A binding contract for the sale of goods was formed, and the supplier's failure to deliver constitutes a breach, entitling MS Sharma to remedies under the UCC. Explanation: this scenario is professionally challenging because it requires a paralegal to navigate the complexities of contract formation and potential defenses, specifically focusing on the application of the Uniform Commercial Code, UC, Article 2, to a sale of goods transaction within Florida's regulatory framework for registered paralegals. The paralegal must accurately identify whether a binding contract exists, and if so, whether a breach has occurred, all while adhering to the strict jurisdictional requirements of the Florida Registered Paralegal (FRP) exam. The core of the challenge lies in distinguishing between a valid offer and a mere invitation to negotiate, and then determining if a clear acceptance, supported by consideration, has been communicated, all within the context of a sale of goods governed by the UCC. The correct approach involves meticulously analyzing the communication between the parties to determine if all elements of contract formation under Florida law and UCC Article 2 are present. This includes identifying a definite offer with specific terms, a clear and unequivocal acceptance communicated to the offerer, and the exchange of something of value consideration to support the agreement. For a sale of goods, the UCC's Battle of the Forms provisions, UC 2-207, may also be relevant if the acceptance contains additional or different terms. A paralegal must then assess if the subsequent actions constitute a breach, and if any defenses, such as fraud or duress, are applicable and supported by evidence, all while operating within the scope of permissible paralegal practice in Florida. This meticulous, evidence-based analysis ensures compliance with Florida's rules governing paralegal conduct and the substantive contract law applicable to the transaction. An incorrect approach would be to assume a contract exists based on a casual exchange of emails, without verifying the presence of all essential elements of offer, acceptance, and consideration. This fails to acknowledge the legal requirements for contract formation, and could lead to advising a client on a non-existent contract, violating professional duties. Another incorrect approach would be to focus solely on the UCC Article 2 without considering Florida's specific statutory and case law interpretations of contract principles, or to overlook potential defenses that might invalidate the contract, thereby providing incomplete or inaccurate advice. Furthermore, a paralegal acting outside the scope of their authorized practice by providing legal opinions or engaging in unauthorized practice of law would be a significant ethical and regulatory failure. The professional decision-making process for similar situations should involve a systematic review of all communications and evidence. This includes identifying the parties, the subject matter of the transaction, and the timeline of events. A paralegal should then apply the relevant legal principles in this case, Florida contract law and UCC Article 2, to each element of contract formation. If a potential contract is identified, the next step is to analyze for breach and any applicable defenses. Throughout this process, the paralegal must remain mindful of their ethical obligations and the boundaries of their role, seeking attorney supervision when necessary. Question 4. The assessment process reveals that a Florida-based client wishes to sue a company that is incorporated and has its principal place of business in Georgia, but the company also conducts substantial business within Florida. The alleged breach of contract occurred in Florida, and the client resides in Miami-Dade County, Florida. The paralegal is tasked with determining the appropriate court to file the initial complaint. Option A. File the complaint in the United States District Court for the Northern District of Georgia, as the defendant is incorporated and has its principal place of business there. Option B. File the complaint in the Circuit Court for Duval County, Florida, as the defendant conducts substantial business in Florida, and Duval County is a major business hub. Option C. File the complaint in the Circuit Court for Miami-Dade County, Florida, as the client resides there and the cause of action arose in Florida. Option D. File the complaint in the United States District Court for the Southern District of Florida, asserting diversity jurisdiction. Correct answer is D. File the complaint in the United States District Court for the Southern District of Florida, asserting diversity jurisdiction. Explanation. This scenario is professionally challenging because it requires a paralegal to navigate the intricate jurisdictional boundaries between state and federal courts in Florida, specifically concerning the proper venue for filing a civil action. Misunderstanding these distinctions can lead to significant procedural errors, including dismissal of a case, wasted client resources, and potential ethical breaches related to competence and diligence. Careful judgment is required to accurately assess the nature of the claim and the residency of the parties to determine the appropriate forum. The correct approach involves meticulously analyzing the Florida Rules of Civil Procedure, specifically Rule 1.060 regarding venue, and the relevant Florida statutes that define the subject matter jurisdiction of Florida state courts. This approach ensures that the lawsuit is filed in the county and court system that has the legal authority to hear the case. Adhering to these rules is paramount for maintaining the integrity of the legal process and fulfilling the paralegal's duty of competence and diligence to the client, as mandated by the Florida Bar rules and regulations. An incorrect approach of filing in a federal court without a clear basis for federal question jurisdiction or diversity jurisdiction would be a significant regulatory and ethical failure. This demonstrates a lack of understanding of the jurisdictional limitations of federal courts and the specific requirements for removal or original federal jurisdiction, violating the duty of competence. Similarly, filing in a Florida state court that lacks proper venue, even if it is a state court, would also be a failure. This could stem from an incorrect interpretation of Rule 1.060, leading to the case being dismissed or transferred, which is a failure of diligence and competence. Another incorrect approach would be to rely solely on the client's preference without independently verifying the legal requirements for venue, which bypasses the paralegal's professional responsibility to ensure legal compliance. A professional decision-making process for similar situations should involve a systematic review of the facts, identification of the relevant legal issues, thorough research of applicable Florida rules of civil procedure and Florida statutes, and consultation with the supervising attorney when any doubt arises regarding jurisdiction or venue. This ensures that all legal requirements are met before initiating legal action, protecting the client's interests and upholding professional standards. Question 5. Assessment of the most effective strategy for an FRP to advise a client who alleges they suffered a severe injury due to a defective product purchased from a retail store, where the injury occurred on the store's premises due to a hazardous condition that the store failed to address, and the client also received negligent medical treatment for the initial injury. Option A. Advise the client on the elements of products liability, premises liability, and medical malpractice claims under Florida law, and assist the attorney in researching and drafting complaints that plead all potentially viable causes of action, while also considering any applicable defenses. Option B. Recommend pursuing only a premises liability claim against the store, as the injury occurred on their property and they failed to maintain safe conditions. Option C. Focus solely on a product's liability claim against the manufacturer, as the defective product is the primary cause of the initial injury. Option D. Advise the client to prioritize a medical malpractice claim, as the negligent treatment exacerbated the original injury. The correct answer is A. Advise the client on the elements of product's liability, premises liability, and medical malpractice claims under Florida law, and assist the attorney in researching and drafting complaints that plead all potentially viable causes of action, while also considering any applicable defenses. Explanation. This scenario is professionally challenging because it requires a Florida-registered paralegal, FRP, to navigate the complex interplay between a client's potential claims and the ethical obligations owed to the court and opposing counsel. The FRP must exercise careful judgment to ensure that all potential avenues for relief are explored, while adhering strictly to Florida's rules of civil procedure and the Florida Bar's rules regulating the profession. The core challenge lies in identifying the most appropriate legal framework for the client's situation, considering the nuances of different tort theories and the specific factual allegations. The correct approach involves a thorough analysis of the client's factual narrative to determine which tort theory or theories best align with the established elements under Florida law. This requires understanding the distinct requirements for negligence, duty, breach, causation, damages, intentional torts, assault, battery, false imprisonment, defamation, products liability, premises liability, medical malpractice, and professional negligence. The FRP must then consider applicable defenses and the types of damages recoverable. This methodical, element-by-element assessment ensures that the chosen legal strategy is grounded in Florida substantive law and procedural rules, maximizing the client's chances of success while maintaining professional integrity. This aligns with the FRP's role in assisting attorneys by conducting factual investigations, legal research, and drafting legal documents that support a legally sound claim. An incorrect approach would be to prematurely focus on a single tort theory, without a comprehensive review of all possibilities. For instance, immediately assuming a premises liability claim without considering if the facts also support a negligence claim against a specific individual or entity responsible for the condition that caused harm would be a failure. This overlooks potential alternative or concurrent causes of action and may limit the client's recovery. Another incorrect approach would be to advise the client on the likelihood of success without a full understanding of all relevant facts and legal elements, potentially mismanaging client expectations and violating ethical duties of competence. Furthermore, failing to consider potential defenses that the opposing party might raise would be a significant oversight, as it could weaken the overall legal strategy. Professional decision-making in such situations requires a systematic process. First, meticulously gather all facts from the client and any available evidence. Second, conduct thorough legal research on all potentially applicable tort theories under Florida law, paying close attention to the specific elements required for each. Third, analyze how the gathered facts satisfy or fail to satisfy those elements. Fourth, identify any potential defenses and their applicability. Finally, based on this comprehensive analysis, assist the attorney in formulating the strongest legal strategy, which may involve pursuing multiple claims or focusing on the most viable one. Question 6. Upon reviewing a new client's business plan for a consulting service that anticipates significant client interaction and potential for contractual disputes, and considering the client's stated desire to protect their personal assets from business liabilities, which of the following approaches best aligns with Florida's regulatory framework for business organizations and the FRP's duty of competent assistance? Option A. Advise the client to simply begin operations under their own name without formal business registration, as this is a common starting point for many small businesses. Option B. Suggest the client form a general partnership with a trusted associate, as this allows for shared responsibilities and resources. Option C. Advise the client to establish a Florida Limited Liability Company, LLC, to provide a legal separation between personal and business assets, thereby limiting personal liability for business debts and obligations. Option D. Recommend that the client operate as a sole proprietorship, as it is the simplest and least expensive business structure to establish in Florida. The correct answer is C. Advise the client to establish a Florida Limited Liability Company, LLC, to provide a legal separation between personal and business assets, thereby limiting personal liability for business debts and obligations. Explanation. This scenario presents a common challenge for a Florida-registered paralegal, FRP, involving the formation of a business entity and the potential for personal liability. The core professional challenge lies in accurately advising a client on the most suitable business structure to achieve their goals while mitigating personal risk, all within the confines of Florida law and ethical obligations. The FRP must possess a thorough understanding of the distinctions between sole proprietorships, partnerships, and limited liability companies, LLC, in Florida, particularly concerning liability protection and operational requirements. The correct approach involves a comprehensive analysis of the client's specific business objectives, risk tolerance, and operational plans, followed by providing informed guidance on the formation of a Florida Limited Liability Company, LLC. This approach is best professional practice because Florida Statutes Chapter 600(5) governs LLCs, offering a distinct legal shield that separates the business's liabilities from the personal assets of its members. By recommending an LLC, the FRP is facilitating the client's ability to operate their business with limited personal exposure, a primary concern for many entrepreneurs. This aligns with the FRP's duty to provide competent assistance and to act in the client's best interest, ensuring compliance with Florida's business organization laws. An incorrect approach would be to advise the client to operate as a sole proprietorship. This is professionally unacceptable because a sole proprietorship, under Florida law, offers no liability protection. The business's debts and legal obligations are directly attributable to the individual owner, exposing their personal assets to significant risk. Recommending this structure without fully explaining the liability implications would be a failure to provide competent advice and could lead to detrimental financial consequences for the client. Another incorrect approach would be to suggest forming a general partnership without clearly outlining the unlimited personal liability that partners face under Florida law for partnership debts and actions of other partners. Similar to a sole proprietorship, a general partnership does not shield personal assets from business liabilities, making it an inappropriate recommendation when liability mitigation is a key client concern. Finally, advising the client to proceed without any formal business structure and simply operate under their own name, while technically a sole proprietorship, is also an incorrect approach. This fails to address the fundamental need for a recognized legal entity that can offer liability protection and facilitate business operations, thereby neglecting the client's need for sound legal guidance on business formation. The professional reasoning process for similar situations should begin with a thorough client intake to understand their business goals, operational scope, and risk tolerance. This should be followed by a detailed review of relevant Florida statutes and case law pertaining to business organizations. The FRP should then analyze the advantages and disadvantages of each potential business structure in light of the client's specific circumstances, focusing on liability, taxation, administrative requirements, and operational flexibility. The final recommendation should be clearly communicated to the client, along with a comprehensive explanation of the implications of the chosen structure, empowering the client to make an informed decision. Question 7. Risk assessment procedures indicate that a client seeking dissolution of marriage in Florida is expressing strong opinions regarding the division of marital assets and the amount of child support they believe is appropriate, based on their perception of the other spouse's financial situation and their own perceived needs. The client has provided some financial documents, but has not fully disclosed all income sources. The client also expresses frustration with the other spouse's perceived lack of cooperation regarding parenting time. Which of the following approaches best represents the professional and legally compliant course of action for a Florida-registered paralegal in this situation? Option A. Recommend to the client that they refuse to allow the other spouse to exercise their scheduled parenting time until the other spouse agrees to the client's proposed child support amount, as this is a common tactic to ensure compliance. Option B. Inform the client that while their feelings are understood, the final determination of alimony, child support, and property division will be based on statutory guidelines and judicial discretion, after a full disclosure of all financial information from both parties, and begin the process of gathering all necessary financial documentation and relevant parenting information to prepare for statutory calculations and negotiations. Option C. Proceed with drafting the dissolution petition based solely on the client's stated desires and the limited financial information provided, assuming the court will adjust figures later if discrepancies are found. Option D. Advise the client that based on the length of the marriage and the disparity in income they have described, they are likely entitled to a significant award of alimony and a disproportionate share of the marital assets, and proceed to draft pleadings reflecting these assumptions. Correct answer is D. Advise the client that based on the length of the marriage and the disparity in income they have described, they are likely entitled to a significant award of alimony and a disproportionate share of the marital assets, and proceed to draft pleadings reflecting these assumptions. Explanation. This scenario presents a professional challenge due to the inherent sensitivity and potential for conflict in family law matters, particularly concerning child custody and support. A Florida-registered paralegal, FRP, must navigate these complexities with a thorough understanding of Florida statutes and ethical obligations to ensure client representation is both effective and compliant. The core challenge lies in balancing the client's stated desires with the legal requirements and best interests of the child, as mandated by Florida law. The correct approach involves meticulously gathering all necessary documentation and information related to the client's income, expenses, and the child's needs, and then applying the relevant Florida statutes, specifically Chapter 61, to calculate child support and advise on potential alimony and property division. This approach is correct because it adheres strictly to Florida's statutory framework for dissolution of marriage, child support guidelines, Florida Statute Section 61:30, and alimony considerations, Florida Statute Section 61:08. It prioritizes accurate factual investigation and legal application, which are fundamental duties of an FRP under Florida bar rules and the FRP certification requirements. This ensures the client receives informed advice grounded in the law. An incorrect approach would be to solely rely on the client's assertions about the other parent's income, without independent verification. This fails to meet the professional obligation to conduct due diligence and could lead to inaccurate financial disclosures, potentially resulting in an unfair child support order or property division. Ethically, this could be construed as assisting in misrepresentation. Another incorrect approach would be to advise the client that they are automatically entitled to a specific percentage of the marital assets or a particular amount of alimony based on the length of the marriage alone, without considering the statutory factors outlined in Florida Statute Section 61:08 for alimony, or the equitable distribution principles under Florida Statute Section 61:075 for property division. This oversimplifies complex legal determinations and misinforms the client about their rights and obligations. Finally, advising the client to withhold visitation based on a disagreement over child support payments is a significant ethical and legal failure. This directly contravenes Florida law regarding parental responsibility and visitation, and could expose the client to contempt proceedings. The professional decision-making process for similar situations should involve 1. Thoroughly understanding the client's objectives and concerns. 2. Identifying all relevant Florida statutes and case law applicable to the specific issues, dissolution, custody, support, alimony, property. 3. Conducting comprehensive factual investigation, including obtaining financial documentation. 4. Applying the law to the gathered facts to provide accurate legal advice and strategic recommendations. 5. Continuously consulting with the supervising attorney to ensure all actions and advice are legally sound and ethically compliant. Question 8. Performance analysis shows that during a residential real estate closing, a Florida-registered paralegal, FRP, discovers a previously undisclosed lien that appears to have priority over the buyer's mortgage. The buyer expresses confusion about the implications of this lien on their ownership and the closing process. The FRP has extensive experience with real estate closings and understands the general legal principles of lien priority. What is the most appropriate course of action for the FRP? Option A. Draft a revised closing statement that attempts to address the lien issue by adjusting the purchase price or escrow arrangements without attorney review. Option B. Inform the buyer that the lien issue is a minor detail and that closings often proceed with such minor encumbrances. Option C. Explain to the buyer the potential legal ramifications of the lien's priority and advise them on whether to proceed with the closing. Option D. Consult with the supervising attorney to discuss the discovered lien and seek specific instructions on how to advise the client and proceed with the closing. The correct answer is C. Explain to the buyer the potential legal ramifications of the lien's priority and advise them on whether to proceed with the closing. Explanation. Scenario analysis. This scenario presents a common challenge for Florida-registered paralegals, FRP, involving potential conflicts of interest and the unauthorized practice of law (UPL). An FRP must navigate the delicate balance between providing substantive legal assistance to clients and adhering to the strict ethical and regulatory boundaries that define their role. The challenge lies in identifying when assistance crosses the line from permissible support to prohibited legal advice or representation, particularly when dealing with complex real estate transactions, where client understanding and legal compliance are paramount. Correct approach analysis. The correct approach involves the FRP recognizing the limitations of their role and proactively seeking guidance from the supervising attorney. This aligns with Rule 3.7 of the rules regulating the Florida Registered Paralegal Program, which mandates that FRPs shall not engage in the practice of law. By consulting the attorney, the FRP ensures that any advice or action taken on behalf of the client is within the scope of authorized legal services and does not constitute UPL. This approach upholds the integrity of the legal profession, protects the client from potentially erroneous or unauthorized legal advice, and safeguards the FRP from disciplinary action. Incorrect approaches analysis, providing specific legal advice regarding the interpretation of lien priority and its implications for the buyer's closing obligations, constitutes the unauthorized practice of law. This violates Rule 3.7 of the rules regulating the Florida Registered Paralegal Program, which prohibits FRPs from engaging in the practice of law. Such advice, even if based on general legal principles, requires the judgment and licensure of an attorney. Drafting a revised closing statement that alters the agreed-upon terms or introduces new legal obligations without direct attorney instruction and review also constitutes the unauthorized practice of law. While FRPs can assist in document preparation, they cannot unilaterally modify legal documents or create new legal commitments for the client. This action bypasses the attorney's oversight and could expose the client to unforeseen legal risks. Directly advising the client on whether to proceed with the closing, despite the discovered lien issue, based on the FRP's personal assessment of the legal risks, is also UPL. This involves legal judgment and risk assessment that is exclusively reserved for licensed attorneys. The FRP's role is to present factual information and facilitate communication with the attorney, not to make substantive legal recommendations. Professional reasoning. When faced with a situation where a client's understanding of complex legal matters, such as lien priority in a real estate closing, is unclear, or when a discrepancy arises that could impact the transaction's legal validity, an FRP's primary responsibility is to defer to the supervising attorney. The decision-making process should involve 1. Identifying the legal issue and its potential impact on the client. 2. Recognizing the boundaries of the FRP's authority and expertise. 3. Immediately communicating the issue and the client's concerns to the supervising attorney. 4. Awaiting specific instructions from the attorney regarding how to proceed, including any communication or document revisions. This ensures that all legal advice and actions are taken under the direct supervision of a licensed attorney, thereby protecting the client and upholding professional standards. Question 9. Implementation of a paralegal's role in assisting a close personal friend with the drafting of their last will and testament, where the paralegal is aware they may be a beneficiary in the will, presents a significant ethical dilemma. What is the most appropriate course of action for the Florida registered paralegal in this situation? Option A. Decline to draft the will and advise the friend to seek independent legal counsel from an attorney unaffiliated with either party. Option B. Draft the will and include a clause acknowledging the paralegal's personal relationship with the testator and their potential beneficiary status. Option C. Draft the will based on the friend's instructions, ensuring the friend understands the terms, and have another attorney review it without disclosing the personal relationship. Option D. Proceed with drafting the will, as the friendship implies a level of trust that supersedes potential conflicts of interest. The correct answer is A. Decline to draft the will, and advise the friend to seek independent legal counsel from an attorney unaffiliated with either party. Explanation: this scenario presents a professional challenge due to the paralegal's direct involvement in drafting a will for a client who is also a close personal friend. The primary ethical and regulatory concern is the potential for undue influence and the appearance of impropriety, which could invalidate the will and lead to disciplinary action. Florida law, specifically the rules regulating the Florida bar, emphasizes the importance of avoiding conflicts of interest and maintaining professional objectivity. A paralegal must act with integrity and competence, and assisting a close friend in drafting their will, especially if the paralegal might benefit directly or indirectly, blurs the lines between personal and professional relationships. Careful judgment is required to ensure the client's wishes are genuinely represented and that no coercion or undue advantage is taken. The correct approach involves recognizing the inherent conflict of interest and the potential for impropriety. A paralegal's duty is to the client's best interests, free from personal bias or external pressure. In this situation, the paralegal should decline to draft the will themselves. Instead, they should advise the client to seek independent legal counsel from a qualified attorney who has no personal relationship with either the client or the paralegal. This ensures that the will is drafted impartially, with the client's true intentions being the sole focus, and that the document will withstand legal scrutiny. This aligns with the Florida Registered Paralegal's ethical obligations to uphold the integrity of the legal profession and to avoid actions that could compromise the validity of legal documents or the client's rights. An incorrect approach would be to proceed with drafting the will, believing that the friendship negates any conflict. This fails to acknowledge the Florida bar's rules regarding conflicts of interest and the appearance of impropriety. Even if no actual undue influence occurs, the perception of it can be enough to lead to challenges and potential invalidation of the will. Another incorrect approach would be to draft the will but have another attorney review it without disclosing the personal relationship. This is a form of deception and fails to address the root conflict of interest. The review attorney cannot provide truly independent counsel if they are unaware of the paralegal's personal stake. A third incorrect approach would be to draft the will and assume the client's wishes are paramount without ensuring they are fully informed of their options and the potential implications of their decisions, especially given the paralegal's personal involvement. This neglects the paralegal's duty to facilitate informed decision-making by the client, which is compromised when the drafter has a personal relationship. The professional reasoning process for similar situations should begin with a clear identification of any potential conflicts of interest, whether actual or perceived. This involves scrutinizing the relationship between the paralegal, the client, and any beneficiaries. If a conflict exists, the paralegal must then consider the ethical rules and guidelines governing their conduct in Florida. The paramount consideration is always the client's best interest and the integrity of the legal process. When a conflict cannot be effectively managed or mitigated, the professional decision is to withdraw from the representation or, as in this case, to advise the client to seek independent counsel from an uninvolved attorney. This proactive approach safeguards the client, the paralegal, and the legal system. Question 10. Which approach would be most appropriate for a Florida registered paralegal tasked with drafting a motion for summary judgment under a strict deadline, ensuring both legal accuracy and compliance with Florida procedural rules and citation standards? Option A. Focus on crafting persuasive legal arguments without verifying factual assertions against the record or ensuring all legal citations are accurate, assuming the supervising attorney will catch any errors. Option B. Prioritize speed by drafting the motion using a template and only performing minimal research to find one or two supporting statutes, without in-depth case law analysis or strict adherence to citation format. Option C. Conduct a broad search on Westlaw for summary judgment in Florida, select a few recent persuasive cases, and draft the motion based on those and general knowledge of the legal standard. Option D. Perform thorough research using Westlaw or LexisNexis to identify controlling Florida statutes and binding case law. Meticulously analyze how the facts of the case align with the legal standards. Draft the motion adhering strictly to Florida Rule of Civil Procedure 1. 510, and ensure all citations conform to the Florida Rules of Appellate Procedure. The correct answer is C. Conduct a broad search on Westlaw for summary judgment in Florida, select a few recent persuasive cases, and draft the motion based on those and general knowledge of the legal standard. Explanation: this scenario presents a professional challenge because a Florida-registered paralegal FRP is tasked with drafting a critical legal document, a motion for summary judgment, under a tight deadline. The challenge lies in balancing the need for speed with the absolute requirement for accuracy, thoroughness, and adherence to Florida's rules of civil procedure and the Florida Bar's ethical guidelines for paralegals. Misinterpreting case law or statutes, or failing to properly cite authority, can lead to a deficient motion, potentially harming the client's case and exposing the paralegal and supervising attorney to disciplinary action. Careful judgment is required to ensure the research is comprehensive, the analysis is sound, and the writing is precise and compliant. The correct approach involves a systematic and thorough legal research and writing process, prioritizing accuracy and compliance. This begins with a deep dive into relevant Florida case law and statutes using Westlaw or LexisNexis, focusing on identifying controlling precedent and statutory provisions that directly support the arguments for summary judgment. This research must be followed by a meticulous analysis of the facts of the current case against the established legal standards. The drafting of the motion must then strictly adhere to Florida Rule of Civil Procedure 1-510, which governs summary judgment, and the Florida Rules of Appellate Procedure for citation format, which largely aligns with the Blue Book. This includes ensuring all factual assertions are supported by record evidence, and all legal arguments are properly cited to controlling authority. This approach is justified by Florida Rule of Civil Procedure 1-110b, which requires pleadings to be signed by an attorney of record, implying that the content must be accurate and well supported, and by the Florida Bar's rules regulating the paralegal profession, which mandate competence and diligence. An incorrect approach that prioritizes speed over accuracy by relying solely on a quick search of recent, potentially non-controlling, cases would be professionally unacceptable. This fails to meet the duty of diligence and competence required of an FRP, as it risks overlooking binding precedent or misapplying the law. Such an approach could lead to a motion that is factually or legally insufficient, violating the implicit duty of accuracy in legal drafting. Another incorrect approach, which involves drafting the motion based on a general understanding of summary judgment principles without specific research into Florida's controlling law and procedural rules, would also be a significant ethical failure. This demonstrates a lack of competence and diligence, as it bypasses the essential steps of legal research and analysis required to craft a persuasive and compliant motion. It also risks violating Florida Rule of Civil Procedure 1-110b's requirement for accurate and well-supported pleadings. Finally, an approach that uses an outdated or inconsistent citation format, even if the legal arguments are sound, would be professionally deficient. While not as severe as a substantive legal error, improper citation can undermine the credibility of the document and demonstrate a lack of attention to detail, which is a core component of professional legal work. Adherence to the prescribed citation format is a matter of professional practice and ensures clarity and consistency in legal writing. The professional reasoning process for similar situations should involve 1. Understanding the objective and the governing procedural rules. 2. Conducting comprehensive legal research using reliable databases, focusing on controlling jurisdiction law. 3. Critically analyzing the research to identify relevant statutes and case law. 4. Applying the law to the specific facts of the case. 5. Drafting the document with precision, ensuring all assertions are supported and all legal authority is correctly cited according to the required format. 6. Reviewing and revising the document for accuracy, clarity, and compliance before submission. Question 11. The analysis reveals that a Florida resident who owns their primary residence with substantial equity exceeding the Florida homestead exemption limits wishes to discharge their unsecured debts and retain their home. They are employed but have experienced recent income fluctuations, which bankruptcy approach, under the guidance of a supervising attorney, best addresses the client's dual goals of debt discharge and homestead protection. Option A, suggesting that the debtor sell their home before filing bankruptcy to avoid complications with equity. Option B, recommending Chapter 11 bankruptcy, as it is designed for individuals with complex financial situations and significant assets. Option C, advising Chapter 7 bankruptcy, focusing on the quick discharge of unsecured debts with the assumption that the homestead exemption will fully protect the property regardless of equity. Option D, recommending Chapter 13 bankruptcy to allow the debtor to propose a repayment plan that includes catching up on any missed mortgage payments and potentially paying the non-exempt equity to creditors over time, while discharging remaining eligible debts. The correct answer is D, recommending Chapter 13 bankruptcy to allow the debtor to propose a repayment plan that includes catching up on any missed mortgage payments and potentially paying the non-exempt equity to creditors over time, while discharging remaining eligible debts. Explanation: this scenario is professionally challenging because it requires a paralegal to navigate the complex distinctions between Chapter 7 and Chapter 13 bankruptcy, specifically concerning the treatment of a debtor's primary residence and the implications for debt discharge. A Florida-registered paralegal, FRP, must possess a thorough understanding of the Bankruptcy Code, Title 11 of the United States Code, and the Federal Rules of Bankruptcy Procedure, as well as relevant Florida exemption laws, to provide accurate guidance. The paralegal's role is to assist the attorney, and providing incorrect information can have severe consequences for the client, including the loss of their home or an unfavorable discharge of debts. Careful judgment is required to identify the most appropriate bankruptcy chapter based on the client's financial situation and goals. The correct approach involves accurately assessing the client's income, debts, and assets, particularly their homestead property, to determine whether Chapter 7 or Chapter 13 is more advantageous. In Chapter 7, non-exempt assets are liquidated to pay creditors, and most debts are discharged. In Chapter 13, the debtor proposes a repayment plan to creditors over 3 to 5 years, often allowing them to keep non-exempt assets by paying their value through the plan. For a debtor with significant equity in their homestead, Chapter 13 may be necessary to protect that equity if it exceeds Florida's generous homestead exemption limits or if they wish to catch up on missed mortgage payments. The paralegal must also consider the client's ability to fund a Chapter 13 plan. An incorrect approach would be to recommend Chapter 7 solely based on the desire for a quick discharge, without fully analyzing the homestead equity and the potential loss of the home. This fails to consider the debtor's specific circumstances and the protections offered by Chapter 13 for significant homestead equity. Another incorrect approach would be to advise the client that all debts will be discharged in Chapter 7 without considering non-dischargeable debts, such as certain taxes, student loans, or domestic support obligations, which is a misrepresentation of the bankruptcy process. Recommending Chapter 13 without confirming the client's ability to make the required plan payments would also be an incorrect and potentially harmful approach, as failure to make payments can lead to dismissal of the case. The professional reasoning process for a paralegal in such a situation should involve 1. Gathering comprehensive client financial information, including income, expenses, assets, with detailed equity calculations for real estate and all types of debts. 2. Consulting with the supervising attorney to discuss the client's situation and potential bankruptcy strategies. 3. Researching applicable federal and Florida state exemption laws, particularly the homestead exemption, to determine which assets are protected. 4. Explaining the fundamental differences between Chapter 7 and Chapter 13, including the implications for asset retention and debt discharge, in a clear and understandable manner to the client, under the attorney's direction. 5. Assisting the attorney in preparing the necessary bankruptcy petitions and schedules, ensuring all information is accurate and complete. Question 12. Stakeholder feedback indicates that many small businesses in Florida are struggling to understand how to protect their innovative products and processes. A client, the owner of a burgeoning tech startup, has developed a novel software application that includes a unique user interface design, a proprietary algorithm that significantly enhances data processing speed, and a distinctive brand name for the application. The client is seeking advice on the most comprehensive and cost-effective strategy to safeguard their intellectual property. Which of the following approaches represents the most prudent and legally sound advice for the paralegal to provide to the client, considering the various forms of intellectual property protection available? Option A. Advise the client to seek patent protection for the brand name and copyright protection for the proprietary algorithm, as these are the most valuable components. Option B. Recommend that the client focus solely on trade secret protection for the proprietary algorithm and the user interface design, as this offers the longest duration of protection. Option C. Suggest that the client prioritize copyright protection for all aspects of the software application, including the algorithm and user interface, as it is the most straightforward form of protection. Option D. Advise the client to pursue patent protection for the software application's algorithm, copyright protection for the user interface design, and trademark protection for the brand name. The correct answer is D. Advise the client to pursue patent protection for the software application's algorithm, copyright protection for the user interface design, and trademark protection for the brand name. Explanation: this scenario is professionally challenging because it requires a paralegal to navigate the complex interplay between different forms of intellectual property and to advise a client on the most appropriate and cost-effective protection strategy. Misidentifying the nature of the intellectual property or recommending an inappropriate protection method can lead to significant financial loss for the client, loss of competitive advantage, and potential legal disputes. The paralegal must exercise careful judgment, relying on their understanding of Florida's specific regulatory framework for intellectual property and the ethical obligations of a Florida-registered paralegal, FRP. The correct approach involves a thorough analysis of the client's invention and business objectives to determine the most suitable form of intellectual property protection. This includes understanding the distinct criteria for copyright, trademark, trade secret, and patent protection under Florida law and relevant federal statutes. The paralegal must then advise the client on the strengths and weaknesses of each option in relation to their specific situation, emphasizing the long-term implications and costs. This approach aligns with the FRP's duty to provide competent legal assistance and to act ethically, ensuring the client receives accurate and beneficial advice. An incorrect approach would be to recommend patent protection solely because the client describes their creation as an invention. Patents are expensive and require public disclosure, which may not be suitable if the client wishes to maintain secrecy. This fails to consider the possibility that the invention might be better protected as a trade secret if its novelty is difficult to prove, or if the client prioritizes secrecy over exclusive rights for a limited period. Another incorrect approach would be to advise the client to rely only on copyright protection for a new software algorithm. While copyright protects the expression of an idea, it does not protect the underlying functional concept or the algorithm itself from being independently developed or used by others. This overlooks the potential for trademark protection for the software's name or trade secret protection for the algorithm if it provides a unique competitive advantage and can be kept confidential. Recommending only trademark protection for a unique manufacturing process would also be incorrect. Trademarks protect brand names, logos, and slogans, not the functional aspects of a process. This approach would leave the core innovation unprotected and vulnerable to imitation, failing to consider patent or trade secret protection, which are designed for such innovations. The professional decision-making process for similar situations should involve 1. Actively listening to and understanding the client's needs and the nature of their creation. 2. Conducting preliminary research into the relevant intellectual property categories, copyright, trademark, trade secret, patent, and their applicability to the client's situation under Florida and federal law. 3. Analyzing the client's business goals, budget, and risk tolerance. 4. Clearly explaining the distinctions between different IP protections, their requirements, benefits, and drawbacks. 5. Recommending a strategic approach that best aligns with the client's objectives, while also advising them to consult with a qualified attorney for formal legal opinions and filings. Question 13. Stakeholder feedback indicates a growing concern among hourly employees in Florida regarding potential underpayment of wages, specifically related to overtime compensation and minimum wage compliance. A client, an hourly employee, reports consistently working more than 40 hours per week without receiving overtime pay and believes their base wage may be below the current Florida minimum wage. The client is seeking guidance on their rights and potential recourse. As a Florida-registered paralegal, what is the most appropriate initial approach to assist this client? Option A. Immediately inform the client that their employer is in violation of federal law and advise them to file a complaint with the Department of Labor. Option B. Recommend that the client seek employment elsewhere and advise them to focus on their current job search rather than pursuing a wage dispute. Option C. Advise the client on the specific Florida statutes and federal laws, FLSA, that govern minimum wage and overtime, gather detailed information about their work hours and pay, and present this information to the supervising attorney for legal analysis and strategy development. Option D. Provide the client with a template demand letter to send to their employer, outlining potential wage and hour violations based on the client's initial statement. The correct answer is C. Advise the client on the specific Florida statutes and federal laws, FLSA, that govern minimum wage and overtime, gather detailed information about their work hours and pay, and present this information to the supervising attorney for legal analysis and strategy development. Explanation. This scenario is professionally challenging because it requires a paralegal to navigate complex employment law statutes and their application to a specific factual situation, all while adhering to the strict jurisdictional requirements of the Florida Registered Paralegal, FRP, designation. The paralegal must accurately identify the relevant legal framework and apply it to determine the appropriate course of action for the client. A misstep could lead to significant legal repercussions for the client and potential ethical violations for the paralegal. The correct approach involves a thorough understanding of Florida's specific employment law landscape, particularly concerning wage and hour disputes. This includes recognizing that, while federal law, FLSA, provides a baseline, Florida law may offer additional protections or have specific procedural requirements. The paralegal must assess whether the employer's actions violate the Fair Labor Standards Act, FLSA, and any applicable Florida statutes regarding minimum wage, overtime, and record-keeping. The paralegal's role is to gather facts, research applicable law, and present findings to the supervising attorney for legal advice and action. This approach prioritizes accurate legal analysis and client advocacy within the bounds of professional responsibility. An incorrect approach would be to rely solely on general principles of employment law, without consulting Florida-specific statutes and case law. This could lead to overlooking crucial state-level protections or procedural hurdles. Another incorrect approach would be to provide legal advice directly to the client, as this is the exclusive purview of a licensed attorney. The paralegal's duty is to support the attorney's representation, not to act as independent legal counsel. Furthermore, failing to thoroughly investigate the factual basis of the claim, such as the employee's job duties and hours worked, would result in an incomplete and potentially inaccurate legal assessment. Professionals should approach such situations by first identifying the client's core legal issue. Then, they must conduct comprehensive research using authoritative sources, prioritizing the specific jurisdiction's laws. In this case, Florida statutes and relevant federal laws as interpreted by Florida courts. This research should be followed by a detailed factual analysis to determine how the law applies to the client's circumstances. Finally, all findings and potential legal strategies should be presented to the supervising attorney for their professional judgment and client advisement. Question 14. The audit findings indicate that a paralegal, acting under the supervision of an attorney, received a direct communication from a client of the firm. The client, who is involved in a contentious divorce proceeding, asked the paralegal for advice on whether to accept a settlement offer from the opposing party, stating they felt pressured by the opposing counsel. The paralegal has also discovered that the opposing counsel is a close personal friend of the supervising attorney. What is the most ethically appropriate course of action for the paralegal? Option A. Contact the opposing counsel directly to discuss the settlement offer and the potential conflict of interest to see if a resolution can be reached without involving the client further. Option B. Advise the client on the pros and cons of the settlement offer based on the case file information, and then inform the supervising attorney of the client's request. Option C. Immediately inform the supervising attorney of the client's communication, the nature of the settlement offer inquiry, and the potential conflict of interest arising from the supervising attorney's relationship with opposing counsel, without offering any advice to the client. Option D. Provide the client with a general overview of settlement negotiations in divorce cases, and then wait for the supervising attorney to address the client's specific inquiry. The correct answer is B. Advise the client on the pros and cons of the settlement offer based on the case file information, and then inform the supervising attorney of the client's request. Explanation. This scenario presents a professional challenge because it directly implicates the Florida Registered Paralegals, FRP, ethical obligations concerning client confidentiality and the unauthorized practice of law. The FRP is in a position of trust, privy to sensitive client information, and must navigate the boundaries of their role to avoid both breaching confidentiality and engaging in UPL. Careful judgment is required to ensure all actions align with the Florida rules of professional conduct. The correct approach involves the FRP immediately and directly informing the supervising attorney about the client's request and the potential conflict of interest. This upholds the attorney-client privilege and confidentiality by ensuring the information is handled by the attorney who has the ultimate responsibility. It also prevents the FRP from inadvertently engaging in UPL by providing legal advice or making decisions that are solely within the attorney's purview. This proactive communication is crucial for maintaining ethical standards and protecting the client's interests. An incorrect approach would be for the FRP to attempt to resolve the conflict themselves by advising the client on how to proceed without consulting the attorney. This would likely constitute the unauthorized practice of law, as providing legal advice is reserved for licensed attorneys. Furthermore, if the FRP were to disclose the nature of the conflict to the opposing party or their counsel, it would be a direct breach of client confidentiality, violating the attorney-client privilege and the FRP's ethical duties. Another incorrect approach would be to ignore the request, hoping it would resolve itself. This inaction could lead to a missed ethical obligation, potential harm to the client, and could be construed as a failure to act diligently, potentially exposing the firm to malpractice claims and disciplinary action. Professionals should approach such situations by first identifying the core ethical principles at play: confidentiality, avoiding UPL, and loyalty to the client. The immediate step should always be to consult with the supervising attorney, providing them with all relevant facts. This ensures that the attorney can make informed decisions regarding the conflict and client representation, thereby safeguarding both the client's rights and the firm's ethical standing. Question 15. Process analysis reveals that a law firm is considering migrating its case management system to a cloud-based platform to enhance collaboration and accessibility. As a Florida-registered paralegal, what is the most critical factor to consider when evaluating potential cloud service providers to ensure compliance with Florida's ethical and regulatory requirements for client data protection? Option A. The provider's adherence to industry-standard security protocols, data encryption capabilities, and a clear data breach notification policy. Option B. The provider's pricing structure and the availability of tiered service plans based on storage capacity. Option C. The provider's marketing materials highlighting user-friendly interfaces and integration with other popular office productivity software. Option D. The provider's ability to offer a free trial period for testing system functionality. The correct answer is D. The provider's ability to offer a free trial period for testing system functionality. Explanation: this scenario presents a common challenge for Florida-registered paralegals, FRP, navigating the integration of technology into legal practice, specifically concerning data security and client confidentiality. The professional challenge lies in balancing the efficiency gains offered by cloud-based case management software with the paramount ethical and regulatory obligations to protect sensitive client information. FRPs must exercise careful judgment to ensure that any technological solution adopted complies with Florida bar rules and relevant statutes governing data privacy and security. The correct approach involves a thorough due diligence process that prioritizes security and compliance. This includes verifying the vendor's security protocols, understanding data encryption methods, reviewing service-level agreements for data breach notification, and ensuring the software's features align with ethical duties of confidentiality. Specifically, FRPs must consult Florida Bar Rule 4-1. Confidentiality of information, and potentially Florida statutes related to data privacy, ensuring that the chosen cloud solution meets or exceeds the required standards for protecting client data. This proactive and informed selection process is crucial for maintaining client trust and avoiding ethical violations. An incorrect approach would be to adopt cloud-based software solely based on cost or perceived ease of use without adequately assessing its security features. This failure to conduct due diligence could lead to a data breach, violating Florida Bar Rule 4-1. By failing to take reasonable steps to protect confidential information. Another incorrect approach is to assume that all cloud providers offer equivalent security, neglecting to review specific contractual terms regarding data ownership, access, and breach response. This oversight can result in unintended data exposure or loss, contravening the FRP's duty to safeguard client information. Furthermore, Failing to implement appropriate access controls and user training for the cloud software, even if the vendor has robust security, can also lead to breaches, as human error or unauthorized access can compromise data integrity. Professional decision-making in such situations requires a systematic approach. First, identify the specific ethical and regulatory obligations relevant to the technology being considered. Second, conduct thorough research and due diligence on potential technology solutions, focusing on security, compliance, and vendor reliability. Third, consult with supervising attorneys regarding the adoption of new technologies, especially those involving client data. Finally, implement robust internal policies and training to ensure ongoing compliance and data protection. Question 16. Consider a scenario where a Florida-registered paralegal, FRP, is assisting an attorney in drafting a motion to dismiss a complaint. The attorney instructs the FRP to research and include a defense based on the principle that the plaintiff has already had their day in court on this specific issue. The FRP encounters the Latin phrase res judicata in their research. Which of the following best describes the FRP's understanding and application of this term within the Florida legal framework? Option A. The FRP considers res judicata to be a generic legal term without a specific Latin origin or established legal meaning. Option B. The FRP believes res judicata is a synonym for stare decisis and applies it to arguments about following judicial precedent. Option C. The FRP interprets res judicata as a procedural deadline for filing certain motions within the Florida court system. Option D. The FRP correctly identifies res judicata as a Latin phrase meaning a matter decided, signifying the legal doctrine that prevents relitigation of issues already judged by a court, and understands its relevance as an affirmative defense in Florida civil procedure. The correct answer is D. The FRP correctly identifies res judicata as a Latin phrase meaning a matter decided, signifying the legal doctrine that prevents relitigation of issues already judged by a court, and understands its relevance as an affirmative defense in Florida civil procedure. Explanation. This scenario presents a professional challenge because it requires a Florida-registered paralegal, FRP, to accurately interpret and apply legal terminology within the specific context of Florida law and procedure. Misunderstanding or misapplying these terms can lead to significant errors in legal documents, client communications, and ultimately, the administration of justice. The FRP's duty of competence, as outlined in the Florida Rules of Civil Procedure and the Florida Bar's rules regulating the paralegal profession, mandates a thorough understanding of such foundational elements. Correct approach involves recognizing that res judicata is a Latin phrase that translates to a matter decided, and signifies the legal principle that a case or issue that has already been litigated and decided by a competent court cannot be relitigated by the same parties. This understanding is crucial for correctly advising clients, drafting pleadings, and conducting legal research within the Florida court system. The Florida Rules of Civil Procedure, particularly those concerning affirmative defenses, implicitly rely on the correct understanding and application of such doctrines. An incorrect approach would be to assume res judicata is a generic legal term without a specific Latin origin, or to confuse it with a similar sounding but distinct legal concept like stare decisis, to stand by things decided, which refers to the principle of following precedent. Another incorrect approach would be to interpret res judicata as a procedural deadline or a specific court filing, which demonstrates a fundamental misunderstanding of its substantive legal meaning. These misinterpretations would violate the FRP's duty to provide accurate legal support and could lead to the filing of improper motions or the omission of critical legal arguments, thereby prejudicing the client and potentially violating ethical obligations to the supervising attorney and the court. Professional decision-making in such situations requires a commitment to continuous learning and a diligent approach to legal research. When encountering unfamiliar or potentially ambiguous legal terminology, an FRP should consult authoritative legal dictionaries, Florida statutes, Florida Rules of Civil Procedure, and relevant case law. If still uncertain, the FRP should seek clarification from the supervising attorney before proceeding. This methodical process ensures accuracy and upholds the professional standards expected of an FRP in Florida. Question 17. Quality control measures reveal that a Florida-registered paralegal, FRP, is preparing interrogatories for a civil litigation matter. The FRP is considering including a question that asks the opposing party to produce all documents, electronic or otherwise, that relate in any way to the plaintiff's alleged injuries, regardless of whether those documents are currently in your possession, custody, or control. Which of the following approaches to drafting this interrogatory is most consistent with Florida's rules of civil procedure and the ethical obligations of an FRP? Option A. Include the interrogatory as drafted, as it seeks broad information relevant to the plaintiff's injuries. Option B. Include the interrogatory as drafted, but add a clause stating that the opposing party may object on grounds of undue burden or privilege. Option C. Revise the interrogatory to specifically request documents that are in the opposing party's possession, custody, or control, and are directly relevant to the nature, extent, and cause of the plaintiff's alleged injuries, as pleaded in the complaint. Option D. Omit any interrogatory related to documents concerning the plaintiff's injuries, relying solely on other discovery methods. The correct answer is A. Include the interrogatory as drafted, as it seeks broad information relevant to the plaintiff's injuries. Explanation. This scenario presents a common challenge in civil litigation, where a paralegal must navigate the complexities of discovery while adhering strictly to Florida's rules of civil procedure and the ethical obligations of a Florida-registered paralegal FRP. The core difficulty lies in balancing the need to obtain comprehensive information for the client's case with the opposing party's right to protection from overly burdensome or irrelevant discovery requests. A paralegal must possess a thorough understanding of the scope of discovery, the permissible methods, and the grounds for objections to ensure compliance and avoid sanctions. The correct approach involves meticulously drafting interrogatories that are specific, relevant to the claims and defenses, and seek information that is not privileged or unduly burdensome to produce. This aligns with Florida Rule of Civil Procedure 1-280, which governs discovery and emphasizes proportionality. By focusing on factual information directly related to the allegations in the pleadings and avoiding requests for broad categories of documents or speculative information, the paralegal acts ethically and effectively. This approach respects the opposing party's rights while diligently pursuing the client's interests, demonstrating professional competence and adherence to procedural rules. An incorrect approach would be to serve interrogatories that are overly broad and seek information that is not reasonably calculated to lead to the discovery of admissible evidence. For example, requesting all documents related to any business transaction of the defendant in the last 10 years, without further specificity, is likely to be objectionable as overly broad and unduly burdensome. This fails to comply with the proportionality principles inherent in Florida's discovery rules and could lead to a motion for protective order or sanctions against the filing party. Another incorrect approach would be to include interrogatories that seek privileged information, such as attorney-client communications or work product, without properly asserting the privilege. This demonstrates a lack of understanding of discovery limitations and could result in ethical violations and damage to the client's case. A third incorrect approach would be to propound interrogatories that are argumentative or designed to harass the opposing party rather than elicit factual information. This violates the spirit of discovery and can lead to sanctions. The professional decision-making process for similar situations requires a paralegal to 1. Thoroughly understand the pleadings and the factual and legal issues of the case. 2. Carefully review Florida rules of civil procedure governing discovery, paying close attention to scope, limitations, and proportionality. 3. Draft discovery requests that are specific, relevant, and narrowly tailored to the needs of the case. 4. Anticipate potential objections and prepare to address them. And 5. Consult with the supervising attorney on complex or potentially contentious discovery matters. Question 18. The monitoring system demonstrates that during a deposition, an expert witness for the opposing party is testifying about their conclusions. The expert states, "Based on my review of the case and what I've been told by the client's former employee, who is no longer available to testify, I've concluded that the product was defective." As a Florida-registered paralegal assisting the attorney, what is the most appropriate immediate action? Option A. Make a note to object to the expert's entire testimony at trial based on hearsay, without informing the supervising attorney during the deposition. Option B. Instruct the expert witness to stop testifying immediately, as their statement clearly violates the hearsay rule under Florida Evidence Code Section 90. 802. Option C. Ask the expert witness clarifying questions about the former employee's statements to determine if they constitute hearsay. Option D. Advise the supervising attorney that the expert's testimony may contain inadmissible hearsay, as the expert is relying on statements from a non-testifying former employee, and recommend further investigation into the admissibility under Florida Evidence Code Section 90.704. Correct answer is D. Advise the supervising attorney that the expert's testimony may contain inadmissible hearsay, as the expert is relying on statements from a non-testifying former employee, and recommend further investigation into the admissibility under Florida Evidence Code Section 90.704. Explanation. This scenario is professionally challenging because it requires a paralegal to navigate the complex rules of evidence, specifically concerning hearsay and expert testimony, within the strict confines of Florida law and the Florida Registered Paralegal (FRP) regulatory framework. The paralegal must not only identify potentially inadmissible evidence, but also understand the procedural implications of challenging or presenting such evidence, all while acting under the supervision of an attorney. The core of the challenge lies in applying the Florida Evidence Code to a situation involving an expert's opinion that may be based on inadmissible hearsay, and determining the appropriate course of action to uphold evidentiary standards and ethical obligations. The correct approach involves the paralegal identifying the potential hearsay issue within the expert's testimony and bringing it to the supervising attorney's attention for strategic decision-making. This aligns with the FRP's role as a legal assistant who must perform tasks under attorney supervision and adhere to the Florida Rules of Civil Procedure and the Florida Evidence Code. Specifically, Florida Evidence Code Section 90.704 permits an expert to base an opinion on facts or data not admissible in evidence if they are of a type reasonably relied upon by experts in the particular field. However, the paralegal's duty is to flag potential issues. The paralegal should research Florida Rule of Evidence 90.801 and 90.802 to understand the definition and inadmissibility of hearsay, and Florida Rule of Evidence 90.702 and 90.704 regarding expert testimony. By identifying the potential hearsay within the expert's basis and advising the attorney, the paralegal is fulfilling their supportive role ethically and competently, allowing the attorney to make the ultimate determination on how to proceed, whether by objecting, cross-examining, or seeking clarification. An incorrect approach would be for the paralegal to unilaterally decide the expert testimony is inadmissible and instruct the witness to refrain from answering based on their own judgment. This oversteps the paralegal's authority, as only the court can rule on the admissibility of evidence. It also fails to involve the supervising attorney, violating the principle of attorney supervision and potentially jeopardizing the case strategy. Another incorrect approach would be to ignore the potential hearsay issue, assuming the expert's testimony is automatically admissible because it comes from an expert. This demonstrates a lack of diligence and a failure to apply the relevant rules of evidence, potentially allowing inadmissible evidence to be presented to the jury. A third incorrect approach would be to attempt to cross-examine the expert on the hearsay issue without attorney direction. This is outside the scope of a paralegal's permitted actions and could lead to procedural errors or prejudice the case. The professional reasoning process for similar situations should involve a systematic approach. First, identify the factual scenario and the legal issue presented, e.g., potential hearsay in expert testimony. Second, consult the relevant Florida Rules of Evidence and Florida Rules of Civil Procedure. Third, analyze the facts against the established rules to determine if a violation or potential issue exists. Fourth, communicate the findings and potential issues clearly and concisely to the supervising attorney, providing relevant rule citations. Fifth, await attorney direction on how to proceed, understanding that the attorney bears the ultimate responsibility for case strategy and evidentiary rulings. Question 19. System analysis indicates that a paralegal working under the supervision of a Florida licensed attorney is assisting a client who wishes to pursue a novel legal strategy. The client is enthusiastic about the potential benefits, but has not fully considered the potential downsides or legal challenges. Which of the following approaches best reflects the professional responsibilities of a Florida registered paralegal in this situation? Option A. Inform the client that the proposed strategy appears too risky and advise them to abandon the idea without further investigation or consultation with the supervising attorney. Option B. Focus research efforts exclusively on legal precedents and arguments that support the client's proposed strategy, aiming to build a strong case for its adoption. Option C. Conduct a thorough risk assessment, identifying potential legal challenges, procedural hurdles, and adverse outcomes associated with the proposed strategy, and then present these findings, along with potential mitigation strategies, to the supervising attorney for review and decision-making. Option D. Immediately proceed with executing the client's instructions as requested, assuming the client has fully considered all implications and that the attorney will provide oversight. The correct answer is C. Conduct a thorough risk assessment, identifying potential legal challenges, procedural hurdles, and adverse outcomes associated with the proposed strategy, and then present these findings, along with potential mitigation strategies, to the supervising attorney for review and decision-making. Explanation: this scenario is professionally challenging because it requires a paralegal to proactively identify and assess potential risks associated with a client's proposed course of action, rather than merely reacting to instructions. The paralegal must exercise independent judgment and apply their understanding of legal principles and ethical obligations to anticipate negative outcomes. This requires a nuanced understanding of the Florida Registered Paralegal (FRP) role, which extends beyond administrative tasks to include substantive contributions to case strategy and client advisement within the bounds of supervision. The correct approach involves a comprehensive risk assessment that considers the likelihood and potential impact of adverse consequences. This aligns with the FRP's ethical duty to assist in providing competent legal services and to avoid conduct that could prejudice the client or the attorney. Specifically, Florida Bar Rule 1-3, 1A, 3 mandates that paralegals act ethically and competently, which includes identifying potential legal pitfalls. Furthermore, the FRP's role, as defined by Florida Rule of Civil Procedure 10-030, necessitates a level of analytical skill that allows for the identification of risks that might not be immediately apparent to the client or even the supervising attorney without focused consideration. A thorough risk assessment allows the paralegal to provide valuable insights to the supervising attorney, enabling informed decision-making and proactive mitigation strategies, thereby upholding the duty of diligence and the principle of zealous advocacy within ethical boundaries. An incorrect approach that focuses solely on executing the client's instructions without any independent risk evaluation fails to meet the professional standards expected of an FRP. This oversight could lead to significant legal repercussions for the client and potential ethical violations for the attorney and paralegal, such as aiding in the unauthorized practice of law if the paralegal is making substantive decisions without adequate attorney oversight or failing to identify clear legal impediments. Another incorrect approach, which involves immediately dismissing the client's idea as too risky without further analysis or consultation with the attorney, demonstrates a lack of critical thinking and an unwillingness to explore potential legal avenues, even if they carry some inherent risk. This can be detrimental to the attorney-client relationship and may violate the duty to explore all reasonable legal strategies. Finally, an approach that involves researching only favorable outcomes without considering potential negative consequences is a form of confirmation bias and a failure to conduct a balanced and objective risk assessment, which is essential for providing sound legal support. The professional decision-making process for similar situations should begin with a thorough understanding of the client's objectives. This understanding should then be followed by an objective analysis of the legal landscape relevant to those objectives, identifying potential legal challenges, procedural hurdles, and adverse outcomes. The paralegal should then consult relevant statutes, case law, and ethical rules to inform their assessment. Crucially, any identified risks or potential issues should be clearly and concisely communicated to the supervising attorney, along with potential mitigation strategies, allowing the attorney to make the ultimate determination on how to proceed. This collaborative approach ensures that the client's interests are protected and that the legal team operates with a comprehensive understanding of the risks and benefits involved. Question 20. Operational review demonstrates that a Florida Registered Paralegal, FRP, has been approached by a client who is involved in a landlord-tenant dispute concerning a lease agreement governed by Florida statutes. The client is asking the FRP to interpret specific clauses of the lease, explain their legal rights and obligations under Florida landlord-tenant law, and advise on the best strategy for negotiating a resolution with the landlord. The FRP has conducted extensive research using Florida statutes and relevant Florida case law. Which of the following approaches best reflects the FRP's professional and ethical obligations in this situation? Option A. The FRP informs the client that they cannot provide legal advice, but offers to draft a letter to the landlord based on the client's instruction, outlining the client's understanding of their rights as derived from the research. Option B. The FRP explains that they are not authorized to provide legal advice and refers the client to a licensed Florida attorney who can assist with the lease dispute and provide legal counsel. Option C. The FRP provides the client with copies of the relevant Florida statutes and case law, allowing the client to review them independently and make their own decisions. Option D. The FRP provides the client with a detailed explanation of the relevant Florida statutes and case law, applying them to the specific facts of the lease dispute, and advising the client on the most advantageous negotiation strategy. The correct answer is D. The FRP provides the client with a detailed explanation of the relevant Florida statutes and case law, applying them to the specific facts of the lease dispute, and advising the client on the most advantageous negotiation strategy. Explanation. This scenario presents a professional challenge because a Florida-registered paralegal, FRP, is tasked with advising a client on a matter that falls outside the FRP's authorized scope of practice, specifically providing legal advice. The FRP must navigate the Florida rules of professional conduct, particularly those governing the unauthorized practice of law and the duty of competence, while also adhering to the Florida statutes and Florida rules of civil procedure relevant to the client's underlying issue. The core of the challenge lies in recognizing the boundaries of the FRP's role and ensuring the client receives appropriate legal counsel without the FRP engaging in conduct that could be deemed the unauthorized practice of law. The correct approach involves recognizing the limitation of the FRP's authority and immediately referring the client to a licensed Florida attorney. This aligns with Florida bar rules and regulations, specifically those prohibiting the unauthorized practice of law by non-lawyers. An FRP is not authorized to provide legal advice, which includes interpreting statutes, predicting case outcomes, or recommending a course of action in a legal dispute. By referring the client, the FRP upholds their ethical obligations to the client and the legal profession, ensuring the client receives competent representation from a licensed attorney. This also demonstrates an understanding of the Florida legal system structure, where licensed attorneys are the sole providers of legal advice. An incorrect approach would be to attempt to provide the legal advice, even if based on research of Florida statutes or case law. This directly violates the Florida rules of professional conduct regarding the unauthorized practice of law. Another incorrect approach would be to provide general information about the law without applying it to the client's specific situation or offering any opinion on how the law might affect their case. While seemingly helpful, this can still be construed as legal advice if it leads the client to believe the FRP is offering legal counsel. Furthermore, failing to refer the client to an attorney when the matter clearly requires legal advice, even if the FRP believes they have sufficient knowledge, is a failure to act ethically and competently, potentially exposing both the FRP and the supervising attorney to disciplinary action. The professional decision-making process for similar situations requires a clear understanding of the FRP's scope of practice as defined by Florida law and the Florida bar. When faced with a request that appears to involve legal advice, the FRP should first identify the nature of the request. If it involves interpretation, application, or strategic recommendations regarding legal matters, it likely constitutes legal advice. The FRP should then consult their supervising attorney if there is any ambiguity. If the request clearly falls outside the FRP's authorized duties, the most ethical and professional course of action is to decline to provide the advice and promptly refer the client to a qualified Florida attorney.